Good morning. Good morning and welcome to PubCA's annual review webcast. We hope you agree this is the most convenient way to hear expert briefings on the year's most important legal developments impacting government contractors. Let me take a minute to tell you about today's lineup. From 9 to 9:50, we'll have a panel on bid protests with the folks here. From 10 to 10:50, claims, disputes, and terminations will be addressed. From 11 to 11:50, intellectual property, information technology, and cybersecurity will be the topics. From 12 to 12:30, there will be a panel on industry trends. From 1:30 to 2:20, costs, pricing, and accounting issues will be addressed. From 2:30 to 3:20, compliance and enforcement issues will be the topic. And lastly, from 3:30 to 4:40, statutes, regulations, executive orders, and policies will be reviewed by the last panel. Whether you're joining us for one, a few, or all of the panels, you're sure to find the information both timely and engaging. You can submit questions to us by live chatting through this webcast platform. We'll get to as many questions as we can. You may need to scroll down the page to view the question submission area. It's recommended not to view the webcast in full screen version. With that, we'll get started. My name is Rich Rector from DLA Piper, and I'm the moderator of the first panel on bid protests. My colleagues on this panel, left to right, are Ralph White of the GAO, Kevin Mullen of Morrison & Foerster, and Dan Graham of Vinson & Elkins. We're going to start today with Ralph, and he's going to cover GAO developments over the past year, and we're going to talk about a couple big cases that came up and were decided by the GAO this year. So Ralph, over to you.
Thank you, Rich. I think anytime we're talking about the GAO bid protest process, one of the first things we always do is start with a conversation about the numbers. Your very first slide has the GAO bid protest statistics that show the fiscal years 13 through 2017. The materials were generally prepared, and we since got our report out. I wouldn't mind giving you a quick update that you could add the numbers of the fiscal 18 filings right down next to the 17 column. I'll just tell you, going down the list, the filings were 2,607. Protests closed were 2,642. The merit decisions, 622. The number of sustains, 92. The sustain rate, 15%. The effectiveness rate, 44%. ADR cases used, ADR 86. The ADR success rate, 77%. And the hearings, 0.51%, or 5 cases. And we'll talk a little bit more about that when we get to Q&As. The biggest development this year for us is that we finally stood up the electronic protest docketing system. You might remember that in the Consolidated Appropriations Act of 2014, Congress directed GAO to create an electronic filing and docketing system. And we developed that and launched it. We are using a filing fee to finance the cost of developing the system. That fee is $350. The system was launched on May 1st, 2018, after a substantial, about 4 or 5 month project, pilot program, in which we migrated each of the pending cases onto the platform and worked the cases using the platform before we actually required that a filing begin there. We've found that certainly from our end, it seems to be working well, and we hear good feedback from the practitioners. But you have several of those here today, and they can also give you their feedback. But we think it's straightforward. It has greatly simplified the fact that the record is all in one location. Generally, pleadings came in the past at GAO by email transmission, and that's fine, except one mailbox got all the documents filed in every case, and with 2,600 cases a year, that made for some record keeping that needed improvement. We also think it's easy to use. We have an immediate notification for agencies of new protests, and there's a real-time access. I just think it has solved a lot of issues for us, including record retention issues that we've had for a long time. So that's the docketing system. The next thing I want to talk about is several large cases. I have slides on 2 of them this year, a couple of the more significant cases. What I thought was interesting as I thought about these was that they all share a single feature, which is they are solicitation challenges. One of the things that you may have seen if you follow government contracts coverage, there was a certain amount of commentary when Oracle first filed its protest challenging the OTA contract that DoD was using I guess this must have been filed in April, March, February or so. But the commentary was that it seemed strange that the companies weren't even waiting until the contract award. What I'd like to say about that is they can, first of all, we get solicitation challenge protests every day. They can be a very effective way for contractors to give feedback to the government on whether or not they think the way the government is doing the procurement works. And just from the point of view of a forum, they are often the easiest kinds of cases to reach a negotiated resolution of, because no one has won or lost yet. That wasn't destined to be the outcome in either of these cases. I think the things that were queued up were pretty controversial. But the first one, the Oracle American decision that came out in May 31st of this year, followed the Army's award of a follow-on other transaction agreement to a company called RAIN Cloud for cloud migration services. It's an interesting area. Another transaction is somewhat hard to define. It's basically whatever, if an agency has the authority to do it, it can generally be whatever the agency wants to call that thing. We had a case a few years ago called Morpho Trust involving the Transportation Security Authority. There were arguments made in that case that because the standard for grants versus contracts in the 1976 Grants and Cooperative Agreements Act sort of spells out definitions. If the definition of what the OTA was looked like a contract as defined by that 1976 Act, we should call it a contract and not an OT. That is not the way that decision came out. And this follows that. The other thing I didn't put on the slide is GAO did an extensive review in the other side of the house, in the audit world, on all of the different other transaction authorities that exist in the government. I think it was spring of 2016. And there are about 16 of these statutes, but this is the only other transaction statute, I'm fairly certain of that, I checked it at the time, that allows follow-on production to be awarded. And there are certain requirements that have to be met in the statute, and that makes this statute different from some of the others. I think you might know the first OTA statute was in the Space Act when NASA was first stood up, but they've been adopted, and pretty much everybody thinks about the one that governs advanced research at places like the Defense Advanced Research Projects Agency. But this is a different one. It does allow follow-on production without further competition.
Without competition, right.
Yes. And so that was a controversy, and as you'll see on the next slide, we found that in the decision that the GAO had not, the Army had not met some of the requirements, and I say the Army actually was an entity within DoD called DIUX that also was involved in this. The Army lawyers defended it. But it was, I'll just mention, it was also a case where we had a hearing this year, and glad we did. There's been a lot of commentary on this Oracle case. One of the things that I might commend to you, in addition to some of it you've heard about, was a very interesting article by the chief of the procurement office at the Army's Tank and Automotive Command in Warren, Michigan, in which he explained how useful the decision was for them to implement other transaction authorities, and viewed it something as a roadmap and a green light to move ahead on those. The other, it's interesting that both of these cases were brought by Oracle. The most recent one is another solicitation challenge filed by Oracle involving what everybody knows now as the JEDI procurement. It's the Joint Enterprise Defense Infrastructure Cloud Procurement. It is a case where there's been challenges to the decision by DoD to make a single award IDIQ contract. That is a thing that Congress has barred by statute, except in certain conditions. The question in front of us was whether or not DOD met those conditions. GAO concluded that it did. That protest was filed very early prior to the time that proposals were due. Later and much closer to the time proposals were due, IBM filed a similar protest raising very similar grounds. After we decided this case, the Oracle company went to the Court of Federal Claims, I think late last week, and we, as of yesterday evening, dismissed the IBM protest because essentially the questions that are in front of the court are going to, when they are answered, are going to essentially be the same answers, they'll be the same questions that were in front of us. And so the court will speak to that, and IBM will either join it or not join it as they see fit. So that's what's happened on the JEDI. I was going to mention one other one. I don't have a slide on it, but another one that's kind of interesting. There's a Boeing Sikorsky decision this year, also a solicitation challenge, or more like a solicitation challenge than an award. In that case, actually, the issues came up in the middle of discussions, but it had to do with how the Air Force was interpreting its solicitation with respect to intellectual property requirements for helicopter procurement. I would commend it to you, and I would just point out to you that if you hear people repeat that mistaken concept that protests generally don't consider solicitation challenges, I would think that 3 of the biggest, most significant cases of this year involved solicitation challenges. So with that, I think it's, I'll turn it over to Mr. Mullen.
Well, let's talk.
Oh, you want to
a
ask?
couple questions?
Certainly.
Yeah, Ralph. So the 2018, the fiscal year 2018 statistics that you provided, the striking thing to me was the reduction or the decline in the number of hearings to just 5 in fiscal year 18. You happened to talk about the 2 Oracle cases where you had a hearing in each of those.
Right.
First of all, what led you to have hearings in those 2 cases?
And I'll mention actually the second Oracle case, that hearing will count for 2019 because it was actually after the 1st of October. But that number is surprising. It was surprising to me. It's been something I've been focused on for a long time. The one thing I can assure you is there has not been any kind of directive at GAO for GAO's hearing attorneys not to hold a hearing. We have noticed several things about them, and one of them is they do increase the cost for the companies that are pursuing a protest. The other thing that happens is there's a pretty high percentage of agencies electing to take corrective action after we call a hearing. I think they are inferring sometimes from the fact that a hearing's been called that they may have a problem. And that's not always a reasonable inference. Sometimes the issue may be that we simply don't feel comfortable trying to write a decision from the record in front of us. So if the record's not really clear, or we're going to need to write something that's going to be out there for the next 4 or 5 decades, you'd like to be able to be sure that you get it right, or at least you can cite to what the agency said as you say what you're saying. So we're getting a lot of corrective action when we try to hold a hearing. Right. But we are doing hearing training. We're having conversations about that. I don't expect to see that number that low again next year. And I can tell you no one said we shouldn't have hearings.
Okay, very good. What about the numbers and experience levels of the hearing attorneys at GAO right now? How does the makeup of your current staff compare to 5 or 10 or 15 years ago, and does that affect how cases are being handled?
You know, I can't pretend that I think there's not some correlation between that. That we've had a demographic sea change at GAO. A lot of people were hired right at the time of the passage of the Competition Act in 1984, and that entire generation generally has left the stage in the last 5 to 10 years. Mm-hmm. So we've had a lot of hiring. We have a lot of newer people, and that's why we're doing training. We're having conversations about these things. We've done other trainings on things like cost accounting issues, just to make sure that everybody feels comfortable with the issues that are brought to us so that we can reach the best answer possible.
Yeah. So the EPDS, the new system that's in place, I think from my point of view, it's been a real success. I think I could get an amen on that from Kevin and Dan.
I agree.
Yeah. How is the system, how is it helping GAO attorneys, and do you have are there any practical pointers that if we had a hearing attorney sitting here today, he'd say, "Well, look, don't do this," or "Don't use the system this way."
It's funny. There's some misunderstandings. Generally, not in places where the contractor is represented by a firm like the firms that the three of you come from. But there are things that you can do as a follow-on in EPDS. You don't have to pay again. So a request for reconsideration, a request for reimbursement of cost after an agency corrective action, a certain number of things where sometimes pro se protesters, and Congress very much cares about pro se protesters, and they want to know that they also can use the system and feel comfortable using it. So there's been on some fronts, that we're trying to make sure that they understand exactly how to use it, and that they don't sometimes pay a second fee when they don't have to. We've reimbursed those fees. I think the attorneys like it. It really does organize the record in a way that's much easier for working on a case afterwards.
Yeah, makes a lot of sense. So on the OTA protest, the Oracle OTA protest, there's a noteworthy fact that I thought was interesting in the decision, that as originally awarded, it had a maximum value of $950 million. And then that value was reduced to $65 million after the protest had been filed. Kind of an unusual step. And it was noted in the decision. But I think it underscores why the size of that protest, that procurement, not a procurement, the size of that OT underscores why Oracle was concerned about it. $950 million without follow-on competition in terms of production. I thought the GAO guidance was very clear, and the fact that the takeaway in that case. What do you think? What would you say the takeaway is for practitioners and because there was some debate.
Users.
Yeah, and agency users, right.
I think that there's a tremendous amount of flexibility that is provided to agencies that have the statutory authority to do another transaction. There are not many avenues for a contractor to get in the middle of, like, who gets selected or what exactly they're buying. But in this one, there were a few conditions precedent for moving from that other transaction to a production contract without competition. And that was, I think there's guidelines there for thinking about where are the guardrails for using another transaction.
Yeah, I know you know that there was some debate or commentary after the decision about whether this unnecessarily restricted the government's ability to issue OTs. I didn't view it that way. The takeaway from me was OTs are a flexible alternative to FAR-based procurements. They can reduce the need for competition in a follow-on phase if it's done right. They can reduce the likelihood of protests if they're done right. And those are obviously attractive qualities for government agencies. But the flexibility, what I read from the GAO is that flexibility is not unbounded. As you said, you got to stay within the guardrails. Right. The statute says you got to do certain things. You got to do those things. Right. Just in November, the DoD published a new other transactions guide, November 2018, that provides guidance on all types of OTs. Previously, there was a guide that had only addressed prototype ITs. And interestingly, in that new guide, it says, first of all, it addresses, it has 10 myths about OTs and then debunks those myths. A nod to Dan Gordon, maybe, in his myth-busting campaign when he was at the OFPP. But it's really helpful. I read those 10 myths and I was like, wow, I didn't know all that. It was really good. But with regard to production OTs, the new guidance says it's consistent with the GAO's decision. It says solicitation documents and the prototype OT agreement itself shall include notice that a follow-on production OT is possible.
Sure. And I would just note that that language that they've added to the new guide is exactly what the statute says. So even the other guide, the previous guide, was pretty useful, and this one looks to be even more useful. And I think it's all of us need to sometimes knock down myths that we hear, because we hear them a lot, and they can take on a life of their own, and we need to address them when they're out there.
Yeah. All right, well, let's turn to Kevin. Kevin is going to address the bid protest reform initiatives that are in the mix this year. There's a number of them, and he's going to take us through and tell us what you need to know about those.
Thanks, Rich. Actually, I'm going to talk about 3, and we'll take them in order. But I'll start off by saying this is a perennial exercise of considering at Congress, pushed by perhaps agencies and perhaps by the press coverage that is sometimes overly simplistic, as Ralph pointed out, that there are real problems with the protest process. There's too many of them, they take too long, they interrupt procurements, and they don't add much value to the system. And speaking of myths, I think that what I'll talk about here today debunks some of those, and we'll see if it has an effect for future consideration by Congress of protest reforms, which I think for learned practitioners, whether they're government or in private practice, the prospect of bid protest reform is frightening, because if it's not done right, it can cause some real damage. So we watch it carefully. So let's start with the first one, which is the RAND study, as I'll call it for short. The 2017 National Defense Authorization Act mandated that DoD undertake a study, basically commission a study in this case, that RAND undertook, to assess the prevalence and impact of bid protests on the Department of Defense procurements. So definitely a worthwhile exercise. RAND was up to the task, as you would expect. They submitted their report to the Department of Defense at the end of 2017. They published it publicly in January of 2018. I'll mention some of the key findings and some of the key recommendations. First, key findings. Less than 0.3% of all DoD procurements are protested. That's an infinitesimal amount, and that shocked me. I knew it was a small number, but what it tells you is that the number of DoD procurements is enormous. So the idea that every procurement is subject to the risk of a protest derailing it is just not correct. Secondly, key finding. Overall, half of all DoD protests are filed by small businesses. That's a surprise too, I think, and an important consideration for future reform activity. Next, nearly 8% of GAO protests involving DoD procurements involve procurements of a value less than $100,000. So a lot of small activity taking up the system. So that's 1 in 12 protests are for under $100,000 contract. Next finding, more than 40% of all GAO protests result in some form of corrective activity, voluntary, sustained in the form of a written decision, but as GAO characterizes it, effectiveness rate is consistently around 40%, and RAND made that observation. I think it's a very poignant one, because it tells you that bid protests address real problems and provide a real value to the procurement system. A real set of guardrails, right? Ralph, is your term. Next, there's no clear evidence that disappointed incumbents are abusing the system. This is a real myth buster, because it's very popular in the press to attack incumbents as taking a knee-jerk protest decision, a decision to protest because they want to preserve their revenue during the course of that 3 months or so. That's a legitimate concern, but it's overblown, as RAND found. The final key finding I'll mention is that DoD task order protests filed by incumbents have approximately 70% chance of getting some corrective action, so of being effective. So for DoD task order protests, really, really high rate of success. So RAND points that out, especially with regard to task order protests, which are also a special focus for potential reform. Now, Rand considered these things, I'm jumping ahead prematurely, and gave some key recommendations. First of all, improve the quality of debriefings. I think we would all second that. Big amen from that one, Rich. Secondly, think carefully before shortening GAO's 100-day timeline for protests. Ralph, you were happy to read that. 100 days, in Rand's view, and probably in your view, is a sprint. And to do it more quickly will sacrifice quality.
10 days is no good, Ralph?
I can't imagine. I cannot imagine how you would do that.
No, not even 99. Ralph is staying at 100. So also, Rand said, think carefully before limiting task order protest jurisdiction. That's been bandied about. It's been limited this way and that way. It's been sliced and diced. Be very careful about that because task order procurements are especially vulnerable to problems as shown by the success rate. Next, consider an expedited, streamlined protest process for the small value procurements under 100,000. Makes perfect sense in terms of efficiency. Next, improve data collection. If you're going to think Congress about making reforms in the future, you got to be better at gathering data to be smart about it. Finally, ensure that the protest reforms, if you're going to make them, Congress, consider carefully the impact on small business because they're filing more than half of the protests. So, in my opinion, Rand did an excellent job in setting up some of the important points for protest reform in the future.
Hey, Kevin, on that first recommendation about debriefings, as we all know, there was a class deviation that was issued in April of 2018 this year for DoD debriefings that implemented the National Defense Authorization Act provision in the prior year. And it requires enhanced debriefings for DoD. What's your impression of how that is working, and Dan, what's your impression of how those new debriefing rules are working?
Well, the first thing is, most importantly, it requires the DoD agency to allow the disappointed offeror to submit written questions within 48 hours of the debriefing, whether it's a written or an in-person debriefing. And it requires the DoD to answer those questions. And once DoD answers the questions, it's at that point that the debriefing closes. If no written questions are submitted by the offeror, well, the debriefing closes when it would typically close. I think this is a good development, but I'd make an observation about it. First of all, I think it's working well, and I'd also say, besides the DoD, I've seen some of the intelligence agencies taking this up in spirit. But I also participated in an in-person debriefing where the agency, in receiving, in one hand, from the Congress about this requirement for written questions post-live debriefing, took away with the other hand and refused to answer any questions during the live debriefing. And I think that's not Congress's intent. The idea was to improve the debriefing, not simply substitute one Q&A opportunity for another. So those are my observations. I think at the end, it's a big improvement, frankly.
Yeah.
Dan?
I think it's had two effects, and they were both the exact effects that we wanted. It's reduced the number of protests because it eliminates the need to file a protest to really understand why you lost. When a company looks at a debriefing and just can't answer the fundamental question, I spent all this money pursuing this opportunity, I don't know why I lost, I have to file a protest, and there must have been something wrong, I have to file a protest to find out. So I think it's reduced those protests. Second, it's also helped focus the issues much earlier on. 100 days is a sprint, and starting the protest with a real granular focus on what the protester believes the procurement error was helps expedite that process.
Yeah. There were a couple decisions from GAO this year on the timing rules related to that. Any surprises from your point of view, Kevin and Dan, of the decisions from GAO and how the rules have been interpreted?
I was a little surprised at the creativity of the protesters with regard to, but I was not surprised that I think that GAO stayed right in the middle and made very prudent and logical decisions about the scope of the debriefing changes. Very sensible.
Yeah.
I agree.
Yeah, very good. Okay.
All right, let's talk about the next important issue for potential bid protest reform. That is Section 822 of the National Defense Authorization Act of fiscal year 2019. That was enacted in August of 2018, And you'll see there's some connections coming out of the RAND study, which occurred before that. First of all, what this section of the NDAA of 2019 does is it addresses this issue, whether it's a problem or not, we can debate, the issue of the second bite at the apple, as it's sometimes called. That is when a protester files a GAO, gets a disappointing decision, and then goes to the U.S. Court of Federal Claims for a second bite at the protest apple. These types of developments are the particular focus of industry, in some instances, the press and agencies, as being doubly disruptive. So that's where Section 822 comes from. And Congress has directed that DOD do a couple of things. First of all, do a study and then issue a report by mid-February of 2019. So it's coming up, that studies this phenomenon. Gathers data on the number of protests that each of those two tribunals, GAO and the Court of Federal Claims, ask questions about the decisions that result, the length of time that the activity takes, the number of times there's a stay of contract performance or an injunction or some other relief that's provided. But the long and short of it is gather all this necessary information so that we can determine exactly what's going on with this second bite at the apple phenomenon. So that's number one. That's a data gathering exercise, and that echoes what Rand suggested. Secondly, Section 822 requires that by mid-May of 2019, DoD set up a data repository that maintains this type of information going forward. Another good suggestion coming out of Rand, I would say. And finally, it establishes an expedited process for those small value contracts, right out of Rand. So it directs DoD to work with GAO, Ralph, you can look forward to this, and to provide a plan by May of 2019 on how we're going to do this. So good developments there, all very sensible. The last thing I'd mention, Rich, is that there is the final of the potential reform items I would mention is a Congressional Research Service report that's called Government Contract Bid Protests, Analysis of Legal Processes and Recent Developments. This is a fairly short, about a dozen pages, beautifully done in my opinion, that talks about how the protest process works at the agencies, at GAO, at the Court of Federal Claims, analyzes the distinctions between the various forums, and then talks about some of the congressional and other studies that have come out. This report serves as a very good platform for congressional staff, Congress members going forward who want to get a tutorial in the protest niceties before considering reform activity. I think it's a valuable piece of reporting.
Very good. On the two bites at the apple issue, Ralph, what data have you seen, if any, on how often that actually happens? In other words, how often does a protester lose at the GAO and then go to the court and pursue the same or related protest grounds?
Sure. It needs to be studied because it will be very helpful if we'll all agree on a definition for what that kind of case is. Mm-hmm. It seems to me that a true second bite at the apple case is one where the protester loses at GAO and goes to the Court of Federal Claims seeking a different answer. That's the posture that the Oracle case is in now. Mm-hmm. However, we do know a little bit about the outlines of these numbers, and that is that the Court of Federal Claims gives out its numbers on protest each year at the West Year in Review Conference, and they've been hovering right around 100 cases a year at the Court of Federal Claims. And they explain that about half of those cases, so I'll take 50, have some prior life at GAO. And what we all know is that a prior life at GAO for a case can take several forms. So there's the situation that Oracle is in. There's the situation of awardees who either an agency takes corrective action in front of us without going to a decision, part of that effectiveness rate that Kevin talked about, or we go all the way to a decision and sustain the protest, and the awardee then, in both cases, goes into the Court of Federal Claims seeking a different answer. That's not what I would view as a second bite at the apple. And the fourth category are cases like the IBM case. I mentioned earlier that we had dismissed IBM last night. The IBM case is one where they were raising the same questions that another company has taken to the Court of Federal Claims. So I would call Oracle's a second bite at the apple. I wouldn't call IBM's a second bite at the apple. So I don't know how much we've sliced those 50 cases that had some prior life at GAO, but I think it might be reasonable to assume that it's about 10. And so we're talking about, should we make changes to the law to address the possibility of 10 cases a year? And also Kevin mentioned the RAND study, which did a really interesting analysis of it's interesting that they chose 11, but the 11 most significant DoD contractors who had filed cases at the court, and it's a tiny number over, I think, 10 or 12 years at the Court of Federal Claims. So that's a lot about 2 bites at the apple, but
Well,
it's
Section
it's relevant and
822
really
study
important.
and report then, Rich, is going to be short, according to Ralph.
I'm not sure that'll be the case.
Maybe someone will read it. There's one other thing, Kevin, that, as you know, is going on in terms of protest developments in the Section 809 panel, the panel that was established by Congress to look at procurement issues across the board, has obviously has expressed an interest in looking at protests and maybe doing something or making recommendations there. There were reports of potentially dramatic changes being considered earlier in the year, and then later reports, well, we're not sure what's going to happen with the Section 809 panel. So those recommendations, I think, are due first quarter of next year. So we're going to have a confluence of things coming together. We have the reports, we have these couple things that additional reports that are underway, and we have the Section 809 panel recommendations. So I think it's going to be next year we'll see what Congress really wants to do on this issue. All right, with that, we're going to turn to Dan Graham, and he's going to talk about the Federal Circuit and their unusual activity this year.
Thanks, Rich. This really was one of the most striking aspects of 2018, the sheer volume of the Federal Circuit's participation in the protest process. The Federal Circuit to date has issued 13 published and unpublished decisions. That's nearly twice and sometimes 3 times more than it's issued in the past. It's hard to say exactly what has caused the spike. I don't think there was a single cause. As Ralph indicated, the Court of Federal Claims protest docket has hovered around 100 cases the last couple of years, but that was a jump from, I believe, 2015, 2014, and prior to that, where they were more in the range of 40 to 60. So some of this increased activity by the Federal Circuit you could attribute to the increased activity at the court, coupled with the natural lag time for appeals to get resolved. Another potential correlation here are the types of cases the Federal Circuit is issuing decisions on. Many of them appear to be the sorts of cases where the Federal Circuit would be in a position to offer meaningful relief after the completion of the appeals process. That's not always the case, and is sometimes a barrier or a disincentive to filing an appeal at the Federal Circuit. If you're just challenging the award of a contract, pending the appeal, the contract could be, performance under the contract could begin, and the Federal Circuit really wouldn't be in a position to offer meaningful relief. There are a number of pre-award protests that were addressed on appeal in the past year, and I think by their nature, those are procurements where the Federal Circuit could actually affect and offer meaningful relief. Similarly, the government appealed a number of the cases that the Federal Circuit decided this year, and the government is always in the driver's seat in terms of proceeding with the procurement after the trial court decision, and those were cases that the Federal Circuit could really meaningfully affect. There were 13 cases. The materials that you have a little bit on each case, but I'm really going to talk about 4, maybe 5, depending on the time we have, that I think really stand out. The first is the Palantir decision. The Palantir decision is one of several decisions in the past several years where the Federal Circuit has addressed FASTA's requirement that agencies procure commercial items on standard commercial terms to the maximum extent practicable. The most recent significant case was CGI Federal in 2015. I think you have to read Palantir along with CGI Federal. In some senses, CGI Federal was a much easier case, cleaner case. That case dealt with an agency's use of non-standard commercial terms to procure a commercial item service. There was nothing in the record indicating that the agency had done any market research indicating whether those non-standard commercial terms were necessary, and the Federal Circuit reversed on that basis. Palantir, there was a very significant record of market research conducted by the agency about the ability of commercial items, commercial software products to fulfill the Army was the procuring agency in that procurement to fulfill the Army's needs. But at the end of the day, the determination that the Army made that developmental items were necessary, that commercial items, commercial software products could not satisfy the need, could not be reconciled with this extensive market research. That the research repeatedly concluded that commercial items were available. Palantir had actually responded to requests for information talking about the capabilities of its commercial products in connection with the Army's needs. But the determination and finding, or it wasn't a determination and finding, excuse me, the written analysis of why the agency went a developmental route simply did not address this extensive market research. Palantir is an important case, but the degree of facts that were in the record that hadn't been tied together by the agency, I think, provides a lot of opportunity for future agencies to distinguish themselves from Palantir. The second case I'll speak to is Augusta-Westland. Augusta-Westland is one of two cases that deal with the scope of the Court of Federal Claims bid protest jurisdiction under the Tucker Act to consider a violation of statute or regulation in connection with the procurement or a proposed procurement. Augusta-Westland has to be thought of in connection along with the Cleveland Assets case, which I'll discuss next, which also addresses the scope of the Court of Federal Claims' jurisdiction under the Tucker Act. Augusta-Westland, I think, was a fairly straightforward application of the Federal Circuit's decision in Distributed Solutions. Distributed Solutions indicated that actions in connection with an RFI pre-solicitation activity was in connection with a procurement and could be protested. Augusta-Westland involved an agency action that completely preceded any identification by the agency of a need that would need to be satisfied with a procurement. Augusta-Westland, the action at issue was the Army's determination that the Lakota helicopter would be the Army's institutional training helicopter. At the time that Army executive order was made, the Army did not perceive the need for procurement of additional helicopters. Ultimately, though, that determination, that executive order was critical when the Army decided to procure approximately 24 additional helicopters. But the Federal Circuit said that decision preceded the identification of any procurement or proposed procurement. That decision is outside the scope of the Tucker Act's jurisdiction. The second case, Cleveland Assets, was really a curveball on the Distributed Solutions analysis. Distributed Solutions focused on the timing of the agency action being challenged. Cleveland Assets involved an allegation that an agency had violated an admittedly appropriation statute in connection with a procurement. Cleveland Assets essentially held that the Tucker Act requires a violation of a, quote, procurement statute. Because the statute that was alleged to have been violated in that case was not a procurement statute, was an appropriation statute, the fact that the violation allegedly occurred in connection with the procurement was not something the court addressed. Importantly, the protester in this case sought rehearing en banc. Two judges, Judges Newman and Wallach, dissented from the denial of rehearing en banc, making exactly this point, that the Tucker Act covers a violation of any statute or regulation so long as that violation occurs in connection with the procurement, and that the Federal Circuit had really, the panel majority had really expanded that or narrowed the reach of that jurisdiction by requiring a violation of a procurement statute. The panel majority's, the panel majority's reasoning was pretty much a floodgates type argument. If we were to allow protesters to challenge any violation of an appropriation statute, we'd be flooded, inundated with protests. And I think that's interesting for a couple reasons. One, it creates a conflict, or at least a very real tension between the approach that GAO takes. GAO has long recognized that Congress often does put restrictions on procurement activities in appropriation statutes. And GAO has repeatedly taken jurisdiction over protests, arguing that in connection with the procurement, an agency did something that Congress had told them not to do in an appropriation statute in connection with that procurement. Clearly, that's not resulted in a flood of appropriations-related protests at GAO. So it's interesting that the Federal Circuit was worried about that effect. The fourth case I'll talk about is Dell Federal Services. Dell is significant because it rejects a standard that several judges on the Court of Federal Claims had applied in connection with corrective action protests. The court below and several other judges had applied a standard that looked to whether the agency's corrective action was narrowly tailored to remedy the error that the corrective action was intended to remedy. The analysis essentially looked at other possible corrective actions that the agency could have taken and asked whether the agency really considered all the possible avenues it could have taken and which of those was the most narrowly tailored. The Federal Circuit said no, that the standard of review is the APA's arbitrary, capricious, abuse of discretion, not in accordance with the law standard. That standard does not require that the agency consider every available option. It requires that the agency pick a reasonable option, even if other options were available.
That's consistent with the GAO,
And
how the GAO
yes,
reads that, right?
So, and I think there was a perception that corrective action protests had a better shot at the Court of Federal Claims than at GAO.
Yep.
I think this really does level the playing field.
Right.
The final case I'll talk about is Continental Service Group. This was an unpublished decision, but I think it's important for three reasons. First, it recognizes that the court can retain jurisdiction over a protest even after the agency has taken corrective action and has decided to go back and do something that could yield an outcome that would moot the protest. GAO would typically say that kind of corrective action renders a protest academic. The court in this case recognized that no, under traditional mootness principles in Article III courts, there are a subset of cases where that corrective action, until it irrevocably, irreversibly addresses the error, justifies the court retaining jurisdiction. Second, there's a lot of great language in this opinion about the purpose of a preliminary injunction and the two goals that preliminary injunctions are intended to achieve. First, maintaining the status quo immediately before the litigation, and second, ensuring that the court has the ability to provide meaningful relief at the end, after a decision on the merits. Ultimately, this was a case where the Federal Circuit reversed the trial court's issuance of an injunction because the Federal Circuit felt that the injunction actually put the protesters in a better position than they were immediately before the protests were filed. Finally, there were a number of statements on the record. I don't believe this was the trial court's specific basis for issuing the injunction, but the trial judge did make explicit her sincere desire that the injunction would result in a negotiated settlement. The Federal Circuit took this opportunity to say that is not a permissible consideration. That is not one of the purposes that a preliminary injunction serves. As I said earlier, there were many other decisions, some precedential, some unpublished. We provided brief explanations of all of them, but this was a tremendously active year for the Federal Circuit with a lot of important decisions coming up.
Will it change next year?
I don't know.
That's a great answer.
I would expect. I do think you'll see a lag. There are a number of cases that were decided this year that I think are going to affect pending cases and going to provide an opportunity and avenue for clarification. Cleveland Assets really was the curveball. That's going to require a revisiting within a couple of years.
Okay. Well, thank you to our panelists, Ralph White, Kevin Mullen, and Dan Graham, for so clearly covering the critical issues in bid protests this year. We're now taking a short 10-minute break, and we hope you join us for our next panel, which is Claims, Disputes, and Terminations at 10 a.m. Thank you.